is an employee and who's an independent contractor? Some answers from Aaron Holt. He is a labor and employment attorney with Cozen O'Connor. Aaron, welcome.
Thanks for having me.
So explain the gist, if at all possible, of the latest ruling by the Department of Labor, clarifying the standards for employees and independent contractors under the Fair Labor Standards Act.
Sure. Well, just recently, the Department of Labor issued an announcement of a proposed rulemaking. They did that in October of last year. What they have is a comment period where they will say, we're going to change an interpretation of the Fair Labor Standards Act, and we would like the public to comment on it. They give about 30 days for that public comment. That closed, and then early January, they announced the new rule. And the new rule is, as you mentioned, just an interpretation of the Fair Labor Standards Act. So it doesn't apply for state laws, and it doesn't apply for any federal laws that have similar independent contractor classifications. For example, the National Labor Relations Act or ERISA would not apply for this particular ruling. But to more directly answer your question, an independent contractor is someone who's excluded from coverage from the Fair Labor Standards Act, right? So they're not the employee of the employer. They are their own employees, so to speak. They run their own business and they're subject to different rules. They might not be provided the same equipment or benefits by the employer. But how you characterize who is an independent contractor and who's an employee is subject to a matter of dispute that we look to the feds to guide us on. And that's what this is additional guidance on who's an employee and who's an independent contractor. Under the old interpretation, under the old rule, the guidance was look at the theoretical control. What ability does the employer have to control the manner and means of the employee's work? And if there is an ability to control, that was considered a very important factor that led toward considering them as an employee.
Would ability to control involve if that was your sole account as a worker, if you were entirely dependent upon that employer for your livelihood?
Yes, the dependence upon the particular employer is a factor both in the old rule and in the new rule. It's just a little bit more, I would say, clarified. The gist of the new rule is that it makes it easier to characterize someone as an independent contractor. It doesn't focus on the theoretical possibility of control so much as the actual practices of the employer. Some of the language they used in this guidance is, quote, the primacy of actual practice. So rather than looking at the theoretical possibility, they're going to look at what is actually happening between the employer and the employee. And they broke out that into a number of different factors, 2 core factors, and then 3 what's known as guidepost factors.
Okay, so does this interpretation, does it involve any substantial change in the way that employers have understood this particular rule or law to work?
I think it emphasizes more actual practices. It makes it easier to characterize some particular people working for you as an independent contractor, which most employers are going to like. But there is something that we need to address, which is the administrative requirements here. The rule goes into effect 60 days after it's announced. So it was announced, I believe, January 7th. So its implementation and effective date is going to be early March. We're going to have a new administration at that point in time. So everything's still up for grabs here. If the Biden administration comes in and says, hold on, we're going to reopen this for public comment, or we don't like the direction this new rule is going and we're going to revisit it, they have the ability to do that. And I would expect that to happen. So
you do expect that to happen?
I think this is mostly going to be a theoretical conversation.
You've seen signs from the Biden administration that he wants to go in a different direction or a slightly different interpretation?
I think reading the tea leaves, that's a reasonable suspicion. That's my suspicion. But anything can happen. It's possible that they decide to go with it. It's already had a public comment period. But given the overtures of the Biden administration in terms of interpretation of the Fair Labor Standards Act and some of the things that they've already said that they're going to push for, like a raised minimum wage at $15 an hour, there's a number of things that I think they are going to try to shift the Department of Labor's focus away from the direction of the Trump administration.
And I'm assuming
we see that with any presidential transition.
Sure. I'm assuming that shift then would involve swinging the pendulum back toward the independent contractor and interpreting that person's work as an employee, thereby eligible for all benefits that the so-called permanent employees have. Right.
Correct. I think the Biden administration would rather people be characterized as employees, subject to those employment protections and benefits, rather than an independent contractor, which is really the thrust of this rule, allowing employers to more easily characterize their workers as independent contractors and let them deal with their own benefits, protections, liabilities on their own.
Sure. Now, you said that this does not affect state law. Each state has its own approach, I suppose, in one way or another. Does state law tend to prevail over federal interpretations of labor standards when it comes to a difference between those two types of rules?
I wouldn't say prevail because they're separate laws, right?
Mhm.
So, for example, if there's a California wage and hour law has different requirements than the federal wage and hour law. Now, you could comply with the federal wage and hour law in California while still not complying with the state law. It just means that you would be sued under a different law. Now, for an employer, that might be cold comfort because the impact to you is going to be the same.
Mhm.
Think of it this way, like the minimum wage. You as an employer have to meet the requisite minimum benefits in the place that you're operating. Now, you can pay someone more than that, but you can't pay them less. So the federal minimum is one standard. And if the state has a higher standard, then you still have to meet that higher standard, but you can't ever go lower than that. And that's essentially, I think, analogous to this situation. As long as you are meeting the minimum, be it state or federal law, then you're going to be okay as an employer, but you just can't go below that.
I wonder if there's one difference between the example of minimum wage laws and the question of independent contractors. As the minimum wage laws can vary even from city to city, from county to county. And I don't imagine that there's that much variance in the interpretation of an independent contractor, not just with states, but within states, jurisdictions, counties, cities, and the like. Or am I wrong?
No, that's a great point. I don't know that interpretation is it. There are some states and local areas that have specifically enacted some regulations in this area. For example, California itself passed a law in the last couple months classifying like Uber drivers and people like that specifically under their own state law. So it might be more granular than that. It might specifically apply to certain classifications of workers that they want to either say this is an independent contractor or it's an employee. So compliance with both state, federal, and, as you know, local ordinances are very important. And I think this is something that we're going to see more of moving forward with the Trump administration and to some extent the Obama administration as well. There's been this influx of local and municipal ordinances interpreting either their own regulations or enacting new regulations that employers have to comply with. I don't see us going back to a world in which state and local law is all you have to worry about. It seems like as we have entered this new era where these local municipalities have found the power to legislate, they're going to continue doing that.
And not only interpretations, but following passage of the California measure, there were many, many petitions for exemption from the law. The question was, well, what about freelance writers? What about truckers? What about artists? What about musicians? It got very confusing. So it sounds like there's still a little bit of a muddy environment out there in which these things are not totally nailed down.
I think that's fair to say. It's one of the areas of law that there's a lot of interests, and the more, I guess, industry groups that have the ability to lobby legislatures, be it at the state, federal, or local level, are going to have more of a seat at the table, and they might get more of the regulation interpretation in their favor. But to more specifically answer that question, it's always at the end of the day going to depend upon that employer and that employee's relationship. What does your employment policy say? How are you interpreting your own employment policies? Who's providing the manner and means in which this work is being performed? Who's providing the equipment? How have you treated other employees in the past? Are you consistently doing it from one worker to another, from one department to another? At the end of the day, that's what employers should really be focused on. That's going to help prevent additional liability.
Broad guidelines, but a case-by-case basis when it comes to actually interpreting them and applying them, it seems.
Absolutely. That's how the court will decide these cases. So that's how employers should think of them.
Yeah. Do you have any insight into the transportation side specifically? Because that is a particular area of controversy, especially in California. The idea of whether drayage drivers like who serve ports, for instance, are actually employed by certain companies or their independents. I'm wondering where that's going these days.
Well, I think California and, the trucking industry specifically is kind of its own animal. There's
Yeah.
a lot of competing interests for interpretation, one way or the other. I think California in and of itself, its own wage and hour laws are different and in flux. I'm here in Texas, so we've actually seen a number of companies that have said, too much, this is too much, and they've relocated some of their operations from California to Texas.
Sure.
Tesla, for example, Oracle's another one.
Mhm.
So we've seen employers kind of take matters into their own hands and say, we don't like the direction of some of these administrative burdens and regulations you're putting on us. So they are moving their business. Now, what I'm curious about is how much the business side of things and the legislature side of things are going to react to that and say, well, maybe we do need to take a step back and make it, some kind of middle ground in terms of regulation, balancing an employer's ability to run their business with the interest in protecting workers and employees.
Do you think the fallout from the pandemic and the current very deep recession has an impact on employer policies in terms of defining who's an employee and who's an independent contractor? And might that have a permanent impact going forward when the economy recovers and the pandemic subsides?
I think so. Honestly, I think that we're not going to go back to a before the pandemic. I think there's a lot of aspects of the workplace that are going to be forever changed. Teleworking, I think, is most notable. But the conversations that I've had with employers about this, and 100% of my practice is devoted towards managing and defending employers and these kind of claims, in addition to some labor claims as well. But all of my conversations have really been with my clients about how are they going to make the business work and keep their employees safe. And some of that is a function of cost, is a bottom dollar business decision, but safety is still important here. I think the employers that have fared the best in this kind of environment have been able to think outside of the box and come up with new and creative ways to both manage their workforce and protect their workers from COVID while still being productive.
Yeah. Some clarification, obviously, from the Department of Labor's current, most recent ruling, but also a story very much in progress. Aaron Holt of Cozen O'Connor, thank you so much for bringing us up to date on where we are now. And I guess we just got to hold the phone and see what happens in the next couple months. But thank you very much for being with me. I really appreciate it.
Thanks for having me.